Sorry ass DJ.
Right to bail, Section 13, Article 3. All persons except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall, before conviction, be bailable by sufficient sureties, or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. Under the rules of court, bail is a security given for the release of a person in custody of the law, furnished by him or a bondsman, to guarantee his appearance before any court as required under certain specified condition. Section 1, Rule 114 of the Rules of Court. Bail is not granted to prevent the accused from committing additional crimes. The purpose of bail is to guarantee the appearance of the accused at the trial, Enrile v. Sandiganbayan. The pertinent provision of the Rules of Court clearly specifies that the purpose of bail is to guarantee the appearance of a person before any court when so required. In fact, the appearance of the accused before the proper court whenever required by the court or by the rules is also one of the conditions in all kinds of bail. Since bail is the security for the release of a person under custody of the law, it is evident that it is not intended to cover the civil liability of the accused in the same criminal case. The money deposited as bail may, however, be applied to the payment of fines and costs, while the excess, if any, shall be returned to the accused or to whoever made the deposit. The question of granting bail to the accused is but an aspect of the criminal action, preventing him or her from eluding punishment in the event of conviction. The grant of bail or its denial has no impact on the civil liability of the accused that depends on conviction by final judgment. Ears of Sarah Marie Palma Burgess v. Court of Appeals. The right to bail emanates from the right to be presumed innocent. It is accorded to a person in custody of the law who may be, by reason of the presumption of innocence he enjoys, be allowed provisional liberty upon filing a security to guarantee his appearance before any court, as required under specific circumstances. People v. Fitzgerald, GR 149723. Any person under detention, even if no formal charges have yet been filed, can invoke the right to bail. T. Hankey v. Rivera, People v. San Diego. However, it is a basic principle that the right to bail can be availed of only by a person who is in custody of the law or otherwise deprived of his liberty, and it would be premature, not to say incongruous, to file a petition for bail for someone whose freedom has yet to be curtailed. Cortez v. Judge Cattrall. Rule 114 provides, among others, that any person in custody who is not yet charged in court may apply for bail with any court in the province, city, or municipality where he is held. In Enrile v. Salazar, where the petitioners were charged with rebellion complex with murder and multiple frustrated murder, the court ruled that based on the doctrine enunciated in People v. Hernandez, the questioned information filed against the petitioners must be read as charging simple rebellion only. Hence, the petitioners are entitled to bail before final conviction as a matter of right. In People v. Judge Donado, it was held that the right to bail cannot be denied one who is charged with rebellion, a bailable offense. In Algol v. Court of Appeals, since the penalty for illegal possession of firearms had been reduced to less than reclusion perpetua, the petitioners were deemed entitled to bail as a matter of right before their conviction by the trial court. In Lavidas v. Court of Appeals, the Supreme Court held that the trial court was in error when the latter required that the arraignment of the accused as a prerequisite to the approval of the bail bond. In the cases when bail is authorized, it should be granted before arraignment. Otherwise, the accused may be precluded from filing a motion to quash. Furthermore, the court would be assured of the presence of the accused at the arraignment precisely by granting bail and ordering his presence at any stage of the proceeding. Exceptions: when charged with an offense punishable by reclusion perpetua or higher, and evidence of guilt is strong. In Carpio versus Judge Maglalang, the Supreme Court said that where the accused is charged with an offense punishable by reclusion perpetua, it is the duty of the judge to determine if evidence of guilt is strong for purposes of deciding whether bail may be granted or not. In People versus Fortes and Fortes versus Judge Guan, it was held that if an accused who is charged with a crime punishable by reclusion perpetua is convicted by the trial court and sentenced to suffer such a penalty, bail is neither a matter of right on the part of the accused nor a matter of discretion on the part of the court. An application for bail must be denied. In People versus Reyes, the Supreme Court held that where a person has been convicted by the trial court and sentenced to the penalty of imprisonment for 22 years, the penalty imposed is classified as reclusion perpetua, and while the case is on appeal, bail may be denied because the offense is punishable by reclusion perpetua and the evidence of guilt is strong. Traditionally, the right to bail is not available to the military. In Comendador versus De Villa, it was held that traditionally, the right to bail has not been recognized and is not available to the military. As an exception to the Bill of Rights, this much was suggested in Arula versus Espino, where the court observed that the right to speedy trial is given more emphasis in the military, where the right to bail does not exist. The denial of the right to bail to the military does not violate the Equal Protection Clause because there is substantial distinction between the military and civilian. Duty of the court when accused is charged with an offense punishable by reclusion perpetua or higher. A hearing on the motion for bail must be conducted by the judge to determine whether or not the evidence of guilt is strong. Whether the motion is resolved in summary proceedings or in the course of regular trial, the prosecution must be given an opportunity to present all the evidence that it may wish to introduce on the probable guilt of the accused before the court resolves the motion for bail. Even if the prosecution refuses to adduce evidence or fails to interpose an objection to the motion for bail, it is still mandatory for the court to conduct a hearing or ask searching and clarificatory questions from which it may infer the strength of the evidence of guilt or lack of it against the accused. Bailon versus Judge Season, 243 Scra, 284, or Maralag versus Judge Cloribel, April 9, 2002. In Tukay versus Judge Dumagas, the court found the judge to have violated the rules of court because although the provincial prosecutor interposed no objection to the petition for bail filed by the accused, it was still incumbent upon the judge to set the petition for hearing and diligently ascertain from the prosecution whether the latter was not really contesting the bail application. In De Los Santos Reyes versus Judge Montesa, the court sanctioned the judge who, after examining the records of the cases forwarded to him by the prosecution, and after finding the existence of probable cause, instead of issuing the corresponding warrants of arrest for the purpose of acquiring jurisdiction over the person of the accused, ex mero motu granted bail to the accused despite the absence, because of prior withdrawal, of a petition of bail, and worse, the lack of hearing wherein the prosecution could have been accorded the right to present evidence showing that the evidence of guilt was strong. In Buzon versus Judge Velasco, the court reiterated the rule that bail is not a matter of right in cases where the offense for which the accused stands charged is punishable by reclusion perpetua, when the evidence of guilt is strong. While it is true that the weight of the evidence adduced is addressed to the sound discretion of the court, such discretion may be exercised only after the hearing called to ascertain the degree of guilt of the accused. At the hearing, the court should assure that the prosecution is afforded the opportunity to adduce evidence relevant to the factual issue, with the applicant having the right of cross-examination and to introduce his own evidence in rebuttal. Without a hearing, the judge could not possibly assess the weight of the evidence against the accused before granting the latter's application for bail. In Vasco versus Judge Repatalo. The Supreme Court reiterated that in the application for bail of a person charged with a capital offense, punishable by death, reclusion perpetua, or life imprisonment, a hearing, whether summary or otherwise in the discretion of the court, must actually be conducted to determine whether or not evidence of guilt against the accused is strong. The hearing on a petition for bail need not at all times precede arraignment, because the rule is that a person deprived of his liberty by virtue of his arrest or voluntary surrender may apply for bail as soon as he is deprived of his liberty, even before a complaint or information is filed against him. When bail is a matter of right, the accused may apply for and be granted bail even prior to arraignment. Even when the charge is a capital offense, if the court finds that the accused is entitled to bail because the evidence of guilt is not strong, he may be granted provisional liberty even before arraignment. In Lavidas v. Court of Appeals, the accused filed a petition for bail as well as a motion to quash, and the court said that in cases where it is authorized, bail should be granted before arraignment, otherwise the accused may be precluded from filing a motion to quash. The court's order granting or refusing bail must contain a summary of the evidence for the prosecution. The assessment of the evidence presented during a bail hearing is intended only for the purpose of granting or denying an application for bail. Not being a final assessment, courts tend to be liberal in their appreciation of evidence, but it is not an uncommon occurrence that an accused person granted bail is convicted in due course, People v. Palarca. Bail is either a matter of right or at the judge's discretion, or it may be denied. Bail in extradition proceedings in Government of the United States of America versus Purganan, 389 Squat 623. One of the issues presented for resolution was whether or not a person facing extradition is entitled to bail. The private respondent maintained that the Philippine Constitution secures the right to bail of all persons, including those sought to be extradited, the only exception being a person who is charged with an offense punishable with reclusion perpetua, when evidence of guilt is strong. He also maintained that the granting of bail would, among others, be consistent with Section 4 of Rule 114 of the Rules of Court, which provides when bail is a matter of right, as in 2004 bar. On the other hand, the petitioner claims that there is no provision in the Philippine Constitution granting the right to bail to a person who is the subject of an extradition request and arrest warrant. The court agreed with the petitioner and advanced the following reasons. The use of the word conviction and the constitutional provision on bail in Section 13 of Article 3 of the Constitution, as well as Section 4 of Rule 114 of the Rules of Court, suggests that bail applies only when a person has been arrested and detained for violation of Philippine criminal laws. It does not apply to extradition proceedings because extradition courts do not render judgments on conviction or acquittal. The constitutional right to bail flows from the presumption of innocence in favor of every accused who should not be subjected to the loss of freedom, as thereafter he would be entitled to acquittal unless his guilt be proved beyond reasonable doubt. It follows, ruled the court, that the constitutional provision on bail will not apply to a case like extradition, where the presumption of innocence is not at issue. Extradition proceedings are not criminal in nature, but sui generis, a class in itself. Since it is not a criminal proceeding, it will not call into operation all the rights of an accused under the Bill of Rights, and does not involve a determination of guilt or innocence. The court, however, did not hold that bail never applies in extradition cases. Instead, the court explained that bail is not a matter of right in extradition cases. However, the judiciary has the constitutional duty to curb grave abuse of discretion and tyranny, as well as the power to promulgate rules to protect and enforce constitutional rights. Furthermore, the right to due process is broad enough to include the grant of basic fairness to extraditees. Indeed, the court stressed that the right to due process extends to the life, liberty, or property of every person. It is dynamic and resilient, adaptable to every situation calling for its application. Exception to the no bail rule in extradition proceedings. In establishing an exception to the no bail rule, the court in Government of the United States of America versus Purganan ratiocinated accordingly, and to best serve the ends of justice, we believe and so hold that after a potential extraditee has been arrested or placed under the custody of the law, bail may be applied for and granted as an exception only upon a clear and convincing showing that 1. Once granted bail, the applicant will not be a flight risk or a danger to the community, and 2. That there exist special, humanitarian, and compelling circumstances, including as a matter of reciprocity, those cited by the highest court in the requesting state when it grants provisional liberty in extradition cases therein. Since this exception has no express or specific statutory basis, and since it is derived essentially from general principles of justice and fairness, the applicant bears the burden of proving the above two-tiered requirements with clarity, precision, and emphatic forcefulness. The court realizes that extradition is basically an executive, not a judicial responsibility arising from the presidential power to conduct foreign relations. In its barest concept, it partakes of the nature of police assistance among states, which is not normally a judicial prerogative. Hence, any intrusion by the courts into the exercise of this power should be characterized by caution, so that the vital international and bilateral interests of our country will not be unreasonably impeded or compromised. In short, while the court is ever protective of the sporting idea of fair play, it also recognizes the limits of its own prerogatives and the need to fulfill international obligations. The Purganan case re-examined 5 years after, on April 19, 2007, in Government of Hong Kong Special Administrative Region versus Olalia Jr. 525 Scra 470. The court ruled anew on the issue of whether or not bail applies to extradition cases in a petition which assailed the order of the RTC of Manila, Branch 8, granting bail to a person subject of extradition proceedings. The court in Hong Kong versus Olalia Jr. re-examined its own ruling earlier made in Purganan. While admitting that the ruling in the previous case of U.S. government versus Purganan falls squarely to the private respondent's case, the court in Hong Kong versus Olalia Jr. viewed the issue in the light of the modern trend in international law, placing primacy on the worth of the individual person and the sanctity of human rights. Specifically, the court pointed out such trends, which it claims it cannot ignore. 1. The growing importance of the individual person in public international law who, in the 20th century, has gradually attained global recognition. 2. The higher value now being given to human rights in the international sphere. 3. The corresponding duty of countries to observe these universal human rights in fulfilling their treaty obligations. And 4. The duty of the court to balance the rights of the individual under our fundamental law on one hand and the law on extradition on the other. The Philippines, added the court, along with the other members of the family of nations, is committed to uphold fundamental human rights as well as value the worth and dignity of every person. The country has the responsibility of protecting and promoting the right of every person to liberty and due process, ensuring that those detained or arrested can participate in the proceedings before a court and to make available to every person under detention such remedies which safeguard their fundamental right to liberty. These remedies include the right to be admitted to bail. In re-examining Purganan, the court made the following observations. First, that the exercise of the state's power to deprive an individual of his liberty is not necessarily limited to criminal proceedings. Respondents in administrative proceedings such as deportation and quarantine have likewise been detained. Second, to limit bail to criminal proceedings would be to close our eyes to our jurisprudential history. Philippine jurisprudence has not limited the exercise of the right to bail to criminal proceedings only. This court has admitted to bail persons who are not involved in criminal proceedings. In fact, bail has not been allowed in this jurisdiction to persons in detention during the pendency of administrative proceedings, taking into cognizance the obligation of the Philippines under international conventions to uphold human rights. noting that bail had in the past been granted in deportation proceedings. The court reasoned that if bail can be granted in deportation cases, it sees no justification why it should not also be allowed in extradition cases. Likewise, considering that the Universal Declaration of Human Rights applies to deportation cases, there is no reason why it cannot be invoked in extradition cases. After all, both are administrative proceedings where the innocence or guilt of the person detained is not an issue. Clearly, explained the High Court, the right of a prospective extraditee to apply for bail in this jurisdiction must be viewed in the light of the various treaty obligations of the Philippines concerning respects for the promotion and protection of human rights. Under these treaties, the presumption lies in favor of human liberty. Thus, the Philippines should see to it that the right to liberty of every individual is not impaired. Obligation and right of the bondsman, arrest without warrant. The bondsman shall surrender the accused to the court for execution of the final judgment. For the purpose of surrendering the accused, the bondsman may arrest him or, upon written authority endorsed on a certified copy of the undertaking, cause him to be arrested by a police officer or any other person of suitable age and discretion. Section 23, Rule 114. An accused released on bail may be rearrested without the necessity of a warrant if he attempts to depart from the Philippines without permission of the court where the case is pending. The authority of the bondsman to arrest or cause the arrest of the accused springs from the old principle that, once the obligation of bail is assumed, the bondsman or surety becomes the jailer of the accused and is subrogated to all the rights and means which the government possesses to make his control over him effective. U.S. v. Addison and Gomez. In Defensor Santiago v. Vasquez, the petitioner who was charged before the Sandiganbayan for violation of the Anti-Graft and Corrupt Practices Act filed through counsel what purported to be an urgent ex parte motion for acceptance of cash bail bond. Said petitioner was at that time confined in a hospital recuperating from serious physical injuries which she sustained in a major vehicular mishap. Consequently, she expressly sought leave that she be considered as having placed herself under the jurisdiction of the Sandiganbayan for purposes of the required trial and other proceedings. On the basis of said ex parte motion and the peculiar circumstances obtaining in that incident, the Sandiganbayan authorized petitioner to post a cash bail bond for her provisional liberty without need of her personal appearance in view of her physical incapacity as a matter of human consideration. Asked in 2012 bar. Forms of bail. Bail may be given in the following forms: corporate surety, property bond, cash deposit, recognizance. Under corporate surety, this is furnished by a corporation under the rules of court and a domestic or foreign corporation which is licensed as a surety and authorized to act as such may provide bail by a bond subscribed jointly by the accused and an officer of the corporation duly authorized by the board of directors. Under property bond, a property bond is an undertaking constituted as a lien on the real property given as security for the amount of the bail. Within 10 days from the approval of the bond, the accused shall cause the annotations on the certificate of title on file with the registry of deeds. If the land is unregistered, it is annotated in the registration book on the space provided therefor in the register of deeds of the province or city where the land lies. The registration is likewise made on the corresponding tax declaration in the office of the provincial, city, and municipal assessor concerned. Within 10 days from the performance of the above acts, the accused shall submit his compliance to the court. His failure to do so shall be sufficient cause for the cancellation of the property bond, his rearrest and detention. Cash deposit. Bail may also be in the form of a cash deposit. The accused or any person acting in his behalf may deposit in cash with the nearest collector or internal revenue or provincial city or municipality, treasurer, or the clerk of court where the case is pending, the amount of bail, Fixed or recommended by the prosecutor who investigated or filed the case. The accused shall be discharged from custody upon submission of the certificate of deposit and a written undertaking showing compliance with the requirements of the rules of court. The money deposited shall be considered as bail and applied to the payment of fine and costs, while the excess, if any, shall be returned to the accused or to whoever made the deposit. Recognizance. This is an obligation of record entered into before some court or magistrate duly authorized to take it, with the condition to do some particular act. The most usual condition in criminal cases being the appearance of the accused for trial. A person in custody may be released on recognizance whenever allowed by law or by the rules of court. The release may be either on the recognizance of the accused himself or that of a responsible person. Release on recognizance may be ordered by the court in the following cases: when the offense charged is for violation of an ordinance, a light felony, or a criminal offense, the imposable penalty of which does not exceed 6 months imprisonment and or 2,000 fine under the circumstances provided in RA 6036. Where a person has been in custody for a period equal to or more than the minimum of the imposable principal penalty without application of the indeterminate sentence law, or any modifying circumstance, in which case the court may allow his release on his own recognizance or on a reduced bail at the discretion of the court. Where the accused has applied for probation pending finality of the judgment but no bail was filed, or the accused is incapable of filing one. D. In case of a youthful offender held for physical and mental examination, trial, or appeal, if he is unable to furnish bail and under the circumstances envisaged in PD 603 as amended, Spirito versus Joe Villanos. In summary procedure, when the accused has been arrested for failure to appear when required, his release shall be either on bail or on recognizance by a responsible citizen acceptable to the court. No, in this case, the release of the accused cannot be effected on his own recognizance. Hey, by the way, if you're not yet subscribed to our channel, please go ahead and hit that subscribe button. It makes me really feel good about myself doing all these audios when you are subscribed. Kaya pa-subscribe naman oh. Tsaka yung notification bell, i-highlight mo siya para ma-notify ka sa next na audio natin. At alam mo ba, kapag hindi mo in-skip yung mga ads, kikita yung channel natin. Isukapay, pangbayad ti bills. Salamat! Duration of the bail. The undertaking under the bail shall be effective upon approval, and unless cancelled, shall remain in force at all stages of the case until promulgation of judgment of the regional trial court, irrespective of whether the case was originally filed in or appealed to it. The bail bond posted by the accused can only be used during the 15-day period to appeal and not during the entire period of appeal. This is consistent with Section 2, letter A of Rule 114, which provides that the bail shall be effective upon approval and remain in force at all stages of the case unless sooner cancelled, until the promulgation of the judgment of the regional trial court. This rule is a departure from the old rules which provided that the bail shall be effective and remain in force at all stages of the case until its full determination and thus effective even during the period of appeal. For the accused to continue his provisional liberty on the same bail bond, consent of the bondsman is necessary. No person under detention by legal process shall be released or transferred except 1. Upon order of the court, 2. When he is admitted to bail. Generally, bail is not required when the law or the rules of court so provide. When a person has been in custody for a period equal to or more than the possible maximum imprisonment prescribed for the offense charged, he shall be released immediately without prejudice to the continuation of the trial or the proceedings on appeal. Also, if the maximum penalty to which the accused may be sentenced is destierro, he shall be released after 30 days of preventive imprisonment. In all these cases, bail is not required prior to the release of the person in custody. In cases filed with the municipal trial court or municipal circuit trial court for an offense punishable by imprisonment of less than 4 years, 2 months, and 1 day, and the judge is satisfied that there is no necessity for placing the accused under custody, he may issue summons instead of a warrant of arrest. Since no arrest is made, bail is not required. Fourth, subject to certain exemptions under Section 1 of RA 6036, bail shall not be required if a person is charged with a violation of a municipal or city ordinance, a light felony, and or a criminal offense that the prescribed penalty for which is not higher than 6 months, imprisonment, and or a fine of 2,000 or both, where it is established that he is unable to post the required cash or bail bond. Bail is not allowed in the following cases. 1. A person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment shall not be admitted to bail when evidence of guilt is strong regardless of the stage of the criminal prosecution. Number 2. Bail shall not be allowed after a judgment of conviction has become final. 3. Bail shall not be allowed after the accused has commenced to serve sentence. Under bail as a matter of right, the general rule is that all persons in custody shall be admitted to bail as a matter of right. As a result, all criminal cases within the competence of the Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court are bailable as a matter of right because these courts have no jurisdiction to try cases punishable by death, reclusion perpetua, or life imprisonment. Likewise, bail is a matter of right prior to conviction by the regional trial court for any offense not punishable by death, reclusion perpetua, or life imprisonment, Enrila v. Sandigan. Hence, bail is a matter of right in the following situations. A. Before conviction by the Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in cities or Municipal Circuit Trial Court. B. After conviction by the courts mentioned in letter A. And C. Before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Examples. A. A person accused of homicide is entitled to bail as a matter of right before his conviction, since the penalty for the offense under Article 249 of the Revised Penal Code is reclusion temporal. If he is convicted, his admission to bail becomes, however, discretionary on the court. B. A person accused of parricide, Article 246 Revised Penal Code, or murder, Article 248 Revised Penal Code, shall not be entitled to bail when evidence of guilt is strong. Said offenses are punishable by reclusion perpetua. What is the remedy when bail is denied? The remedy of the petitioner from the order of the trial court denying an application for bail is to file a petition for certiorari if the trial court committed a grave abuse of its discretion, amounting to excess or lack of jurisdiction in issuing the said order. People v. Gomez. Certiorari is the remedy to annul the order of the court denying the petition for bail. Mandamus may, at the same time, be availed of to compel the grant of bail, which is a matter of right. When bail is a matter of right, the court is left with no discretion but to grant the same. When bail is a matter of right, the same cannot be denied. The probability that the accused will escape or not appear in the trial is not a ground for denial of the right to bail. It is, however, a reason for the court to increase the bail bond to assure his appearance. Thus, it was ruled that when bail is a matter of right, the existence of a high degree of probability that the defendant will abscond confers upon the court no greater discretion than to increase the bond to such an amount as would reasonably tend to assure the presence of the defendant when it is wanted. Such amount to be subject, of course, to the provision that excessive bail shall not be required. San Miguel v. Maceda. How about when bail is a matter of discretion? In Section 4, letter B of Rule 114, Recall that bail is a matter of right before conviction by the regional trial court of an offense not punishable by death, reclusion perpetua, or life imprisonment. But when the accused has been convicted in the regional trial court of an offense not punishable by death, reclusion perpetua, or life imprisonment, the admission to bail becomes discretionary. Since the grant of bail is a matter of discretion, a hearing must be conducted whether or not the prosecution refuses to present evidence, and the prosecutor must be notified to require him to submit his recommendation. This notice of hearing applies in all cases whether bail is a matter of right or a matter of discretion. Sunio versus Kabebe. If the grant of bail becomes discretionary when the accused has been convicted in the regional trial court of an offense not punishable by death, reclusion perpetua, or life imprisonment, it follows that if the penalty imposes death, reclusion perpetua, or life imprisonment, bail should be denied because this means that the evidence of guilt against him is not just strong. His guilt has actually been proved beyond reasonable doubt. Thus, in the early case of People v. Nietzsche 240 Squad 283, the court clearly declared that if an accused is sentenced to suffer reclusion perpetua, his conviction clearly imports that the evidence of guilt is strong. The clear implication, therefore, is that if an accused who is charged with a crime punishable by reclusion perpetua is convicted by the trial court and sentenced to suffer such a penalty, bail is neither a matter of right on the part of the accused nor discretion on the part of the court. In such a situation, the court would not have only determined that the evidence of guilt is strong, which would have been sufficient to deny bail, even before conviction. It would have likewise ruled that the accused's guilt has been proven beyond reasonable doubt. Bail must not then be granted to the accused during the pendency of his appeal from the judgment of conviction. It is a misconception that when an accused is charged with a crime of murder, he is not entitled to bail at all, or that the crime of murder is non-bailable. The grant of bail to an accused charged with an offense that carries with it the penalty of reclusion perpetua is discretionary on the part of the trial court. In other words, the accused is still entitled to bail, but no longer as a matter of right. Instead, it is discretionary and calls for a judicial determination that the evidence of guilt is not strong in order to grant the bail. The prosecution is accorded ample opportunity to present evidence because, by the very nature of deciding applications for bail, it is on the basis of such evidence that judicial discretion is weighed in determining whether the guilt of the accused is strong. San Miguel v. Maceda. The discretion of the court may be exercised only after the hearing called to ascertain the degree of guilt of the accused for the purpose of whether or not he should be granted provisional liberty. This hearing is indispensable. Said hearing may be either summary or otherwise, in the discretion of the court. Where application for bail is to be filed after conviction by the regional trial court, as in Bar 2002, the application for bail may be filed and acted upon by the trial court even if a notice of appeal has already been filed, provided that the trial court has not yet transmitted the original record to the appellate court. Section 5, Rule 114. Corollarily, if the original record has already been transmitted to the appellate court, then the application shall be filed with the said appellate court. The rule allowing the filing of the application for bail in the trial court prior to the transmission of the original record is consistent with Section 6 of Rule 120. The second sentence of the second paragraph of said section provides that the court promulgating the judgment shall have authority to accept the notice of appeal and to approve the bail bond pending appeal. If the decision of the RTC convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed with and resolved by the appellate court, Section 5, Rule 114. Section 6 of Rule 120 has a similar provision, thus, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed and resolved by the appellate court. If the application for bail is granted, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail. This rule is, however, subject to the consent of the bondsman. The consent of the bondsman shall be required to have provisional liberty under the same bail because of the rule in Section 2, letter A of Rule 114, that the undertaking shall be effective until promulgation of the judgment of the regional trial court. When does application for bail after conviction by the RTC be denied? If the penalty imposed is death, reclusion perpetua, or life imprisonment, bail should be denied since the conviction indicates strong evidence of guilt based on proof beyond reasonable doubt. 2. Even if the penalty imposed by the trial court is not any of the above but merely imprisonment exceeding 6 years, the accused shall be denied bail, or his bail already allowed shall be cancelled, if the prosecution shows that the following or other similar circumstances: A. That the accused is a recidivist or quasi-recidivist, a habitual delinquent, or has committed the crime aggravated by the circumstance of reiteration. B. That the accused has previously escaped from legal confinement, evaded sentence, or violated the conditions on his bail without valid justification. C. That the accused committed the offense while under probation, parole, or conditional pardon. D. That the circumstances of his case indicate the probability of flight if released on bail. Or E. That there is undue risk that he may commit another crime during the pendency of the appeal. Section 5, Rule 114 of the Rules of Court. The court is not authorized to deny or cancel the bail ex parte. The rule requires notice to the accused. The resolution of the regional trial court denying or canceling the bail may be reviewed by the appellate court motu proprio or on motion of any party after notice to the adverse party in either case. How about bail pending appeal where penalty imposed exceeds 6 years? In an application for bail pending appeal by an appellant sentenced by the trial court to a penalty of imprisonment for more than 6 years, the discretionary nature of the grant of bail pending appeal does not mean that bail should automatically be granted absent any of the circumstances mentioned in the third paragraph of Section 5, Rule 114 of the Rules of Court. La Vista v. Court of Appeals. 2. The third paragraph of Section 5, Rule 114 applies to 2 scenarios where the penalty imposed on the appellant applying for bail is imprisonment exceeding 6 years. The first scenario deals with circumstances enumerated in the said paragraph not being present. The second scenario contemplates the existence of at least one of the said circumstances. In the first situation, bail is a matter of sound judicial discretion. This means that if none of the circumstances mentioned in the third paragraph of Section 5, Rule 114 is present, the appellate court has the discretion to grant or deny bail. An application for bail pending appeal may be denied even if the bail negating circumstances in the third paragraph of Section 5, Rule 114 are present. On the other hand, in the second situation, the appellate court exercises a more stringent discretion, that is, to carefully ascertain whether any of the enumerated circumstances in fact exist. If it so determines, it has no other option except to deny or revoke bail pending appeal. Thus, a finding that none of the said circumstances is present will not automatically result in the grant of bail. Such finding will simply authorize the court to use the less stringent sound discretion approach. La Vista v. Court of Appeals, 615 SCRA 619. Where none of the circumstances above is present, bail is discretionary. Enrila v. Sandigan. The appellant has no right to be freed on bail pending his appeal from the trial court's judgment, where his conviction carries a penalty of imprisonment exceeding 6 years, and there is a justification for the cancellation of his bail pursuant to the third paragraph of Section 5, letter B, D, and E of Rule 114. The inexcusable non-appearance in court of the appellant not only violated the condition of his bail, that he shall appear before the court whenever required by the court or the rules, it also showed the probability that he might flee or commit another crime while released on bail, Chua versus Court of Appeals. Hearing on application for bail in offenses punishable by reclusion perpetua or life imprisonment. A hearing of the application for bail is to be conducted when a person is in custody for the commission of an offense punishable by death, reclusion perpetua, or life imprisonment. In the hearing, the prosecution has the burden of showing that the evidence of guilt is strong. Section 8, Rule 114, asked in 1998 bar. Aside from the prosecution having the burden of showing that evidence of guilt is strong, the hearing shall be summary. Under Section 7 of Rule 114 of the Rules of Court, no person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Thus, a hearing should be conducted by the court to determine the existence of strong evidence or lack of it against the accused, to enable the judge to make an intelligent assessment of the evidence presented by the parties. As in the 1991 bar, bail cannot be allowed to a person charged with a capital offense or of an offense punishable by reclusion perpetua without a hearing upon notice to the prosecution, Gacal versus Infante, as in the 2011 bar. In Gacal versus Infante, a prosecution for murder, the accused was granted bail without a hearing and upon the recommendation of the public prosecutor. The judge dispensed with the hearing because, accordingly, the accused did not file a petition for bail and that the prosecutor's recommendation of bail had the effect of a waiver of the need for a bail hearing. The reasons adduced by the judge were, according to the court, unwarranted. Even when there is no petition for bail, in a case like the one before the trial court, a hearing should still be held. Also, the fact that the public prosecutor recommended bail for the accused did not warrant dispensing with the hearing. The court further instructed on the same case, the public prosecutor's recommendation of bail was not material in deciding whether to conduct a mandatory hearing or not. For one, the public prosecutor's recommendation, albeit persuasive, did not necessarily bind the trial judge, in whom alone the discretion to determine whether to grant bail or not was vested. Whatever the public prosecutor recommended, including the amount of bail, was not binding, nor did such recommendation constitute a showing that the evidence of guilt was not strong. If it was otherwise, the trial court could become unavoidably controlled by the prosecution. Even cases earlier than that of Gacal versus Infante show the court consistently applying the rule that it is mandatory duty to conduct a hearing even if the prosecution chooses to just file a comment or leave the application for bail to the discretion of the court. Goodman versus De La Victoria. The fact that the prosecutor interposed no objection to the application for bail by the accused does not relieve the judge of the duty to set the motion for bail for hearing. Manegilod versus Paklibon. Cancellation of bail. Remedy. Cancellation by application of the bondsman. Bail may be cancelled upon application of the bondsman with due notice to the prosecutor, A. upon surrender of the accused, or B. proof of his death. Asked in 2011 bar. Automatic cancellation. The bail may be deemed automatically cancelled upon A. acquittal of the accused, B. dismissal of the case, or C. execution of the judgment of conviction. 3. Section 5 of Rule 114 allows the cancellation of bail where the penalty imposed by the trial court is imprisonment exceeding 6 years if any of the ground in the said section is present, as when the circumstances indicate the probability of flight. This order cancelling the bail is subject to review by the appellate court, motu proprio or on motion. It was held in Chua versus Court of Appeals that from the last paragraph of Section 5 of Rule 114, the appropriate remedy against the trial court to order cancelling the bail is by filing with the Court of Appeals a motion to review the said order in the same regular appeal proceedings which the appellant himself initiated, such motion being an incident to his appeal. The filing of a separate petition by a special civil action for certiorari before the appellate court is prescribed and contravenes the rule against multiplicity of suits and constitutes forum shopping. Chua versus Court of Appeals. Application for admission to bail, not a bar to objections on illegal arrest, lack of irregular preliminary investigation. So the application or admission of the accused to bail shall not bar him from challenging both the validity of his arrest or the legality of the warrant issued therefor, provided that he raises them before entering his plea. It shall not likewise bar the accused from assailing the regularity or questioning the absence of a preliminary investigation of the charge against him, provided the same is raised before he enters his plea. The court shall resolve the matter as clearly as practicable, but not later than the start of the trial of the case. Section 26 of Rule 114 is a new rule intended to modify previous rulings that an application for bail or the admission to bail by the accused shall be considered as a waiver of his right to assail the warrant issued for his arrest on the legalities or irregularities thereon. The new rule is curative in nature because precisely it was designed to curb evils in procedural rules. Procedural rules as a general rule operate retroactively, even without express provisions, to actions yet undetermined at the time of their effectivity. Ocave versus Gutierrez. The former ruling that the posting of bail constitutes a waiver of any irregularity in the issuance of a warrant of arrest has already been superseded by Section 26, Rule 114 of the revised Rules of Criminal Procedure. The principle that the accused is precluded from questioning the legality of the arrest after arraignment is true only if he voluntarily enters his plea and participates during trial, without previously invoking his objections thereto. Barlongan versus Peña, 620 Scra 106. At natapos din ang bail. Ang sipag ko magbasa, no? Pero nakakapagod. Kaya kaibigan, huwag kalimutang mag-subscribe ha. Salamat. Ayaw nga pala, kung may comment ka, pakilagay na lang dyan sa comment box sa baba. Hanggang sa muli, paalam!